monitoring?
Brexit creates a challenge for all UK businesses that are processing the data of EU residents. The uncertainty about the status of the relationship between the EU and the UK beyond the 29th of March means that UK companies that are caught by that challenge have to make a decision about what they're going to do to process data legally from the 30th of March onwards. That's challenging because it takes considerable time to put in place the legal arrangements that are necessary, and of course if the UK manages to leave with a deal, then those arrangements might not be necessary. It's a very confusing and challenging time for UK businesses. If Britain leaves the European Union without a deal, apart from all of the problems that will create in so many other fields where the transfer of data is concerned, Britain will immediately become a third country under the General Data Protection Regulation. A third country means that data transferred from the EU to the UK will be transferred in much the same way as data transferred from the EU to Chile or to any other country that has no recognized data protection regime. And that means that the EU countries that are sending the data will be requiring their controllers and processors to put in place a series of much more significant data protection implements than are currently there. The same challenge applies to UK businesses that are processing data offshore or providing services into the European Union. They will have to be able to demonstrate they comply with the extraterritoriality requirements of GDPR, recognizing that breaches of the extraterritorial requirements tend to trigger fines up to 4% of global turnover. They're in the higher tariff range of potential fine for breaches. If Britain leaves the EU without a deal, there is a hope that it will fairly quickly be recognised as an approved country for the purpose of data transfers. However, it has to be remembered that countries like Australia and New Zealand have, in spite of having very well established data protection regimes, have taken many years to be recognised as being an approved country. And one of the worries that has already been expressed within the European Union is the possibility of divergence between the EU and the UK where data protection is concerned, and that worry is likely to delay any recognition of the EU as an approved country for the purposes of data transfer. So any sensible organisation considering what to do beyond the 29th of March in a no-deal scenario would be well advised to assume that Britain won't be recognised as an approved country for a number of years, and that it's necessary therefore to take all of the action that is required as an organisation operating in a third country. If Brexit goes ahead, the UK companies will need to continue adhering to the Data Protection Act 2018, which is the UK's implementation of the GDPR, and they'll need to continue adhering to the Privacy and Electronic Communications regulations, which are, while created by an EU directive, are also part of the UK law. Or to put another way, from a UK perspective, nothing changes in terms of compliance requirements. However, there are significant changes in terms of exporting data to the European Union, as I've already mentioned, but there'll also be significant changes in terms of how the Data Protection Act 2018 is implemented for transfers of data to the United States, for instance, and to a number of other countries which at the moment benefit from being recognized as approved countries under the EU's regulations, but which under GDPR will cease to be recognized as approved countries, by the UK that is. We've recently launched a Data Protection Act 2018 training course. It's available in a classroom version, which you can attend in a physical classroom. And more excitingly, it's available as a distance learning module, which means that you can download it and consume it over a period of time. The Data Protection Act 2018 course includes not just a description of how GDPR has been put into the UK's law, but also sets out the steps that UK companies need to take to deal with the challenges of Brexit, of the circumstances that would apply if Britain leaves without a deal, and what it will need to do beyond Brexit, both in terms of EU data flows, but also data flows with countries that are outside the EU and with which the UK will continue to trade.